I've been the fly on the wall for more than 2 decades of sectional title disputes. I've got the data, the rules, and the real-world solutions. You're watching at Scheme Savvy, Sectional Title Simplified. You've finally found the perfect home in a beautiful estate. But there's one problem. The body corporate says no pets allowed. Is that rule final, or is there a legal path forward? Welcome to At Scheme Savvy. We're drawing on 22 years of expert experience to show you why a blanket ban on your pet, whether it's a dog, a cat, or a parrot, might not be as enforceable as your trustees think. Most owners and tenants don't realize that their rights are anchored in the Sectional Title Schemes Management Act. Specifically, Prescribed Conduct Rule 1 states that trustees cannot unreasonably withhold consent for a pet. This means trustees are legally obligated to consider the individual merits of every single application. In our 2 decades of management, we've seen 3 persistent myths cause 90% of the conflict in modern estates. Myth number 1, blanket bans are legal. Absolute prohibitions are generally unenforceable in modern law. The legal landscape has evolved. Schemes can no longer simply say no just to avoid creating a precedent. Each case must be judged on its own objective criteria. Myth number 2, trustees have the final say. Not quite. While they are the decision makers, their decisions must be based on objective facts, not personal preference or how things have always been done. If a decision is arbitrary or unreasonable, it is legally vulnerable. Myth number 3, verbal consent is enough. This is a major trap. We always advise getting pet approvals in writing. It's the only way to protect both parties if the board changes or management is handed over to a new team. Now, a word for our fellow trustees and managers. We know that your primary goal is community harmony, not endless paperwork. To foster a successful environment, we recommend a managed consent culture. First, standardize your process. Adopt a formal policy that clearly outlines the Reasonableness Test criteria you use to evaluate pets. Second, focus on behavior, not breed. A pet's impact is determined by its training and the owner's responsibility, not a label. And third, keep a formal pet register. Consistency is your best legal defense. When policies are transparent and fair, property values stay high and resident satisfaction remains the priority. What if they allow dogs but ban cats? Recent adjudications have found that selective bans like this are often discriminatory and unreasonable. A body corporate cannot simply say no because they don't want to create a precedent. They must prove that your specific pet would create a nuisance. If they can't prove that, their refusal likely won't hold up if you take it further. So how do you win this battle before it even starts? You become a savvy owner. Don't just ask for permission. Submit a pet CV. This is a professional package that includes vet records, behavioral history, and a clear plan for how you will manage noise and hygiene. When you provide this level of detail, you make it almost impossible for a board to say no without being legally unreasonable. If you are refused, your next stop is the Community Schemes Ombud Service, or CSOS. You have the right to lodge a dispute for free. An adjudicator will look at whether the trustees applied their minds to the facts. If the refusal was arbitrary or based on an outdated no pets sign, the Ombud has the power to set that decision aside. To wrap this up, let's look at your Savvy Action Plan for this week. If you are an owner, don't wait for a dispute. Start building your pet CV today. Get those vet records in order and take a clear professional photo. If you are a trustee, review your current pet rules. Are they outdated? Are they based on blanket bans? If so, it might be time to move toward a managed consent model to protect your board from future litigation. For everyone, remember that property values are highest in schemes where there is harmony and clear communication. But remember, harmony is a two-way street. As much as you have a right to your pet, your neighbors have a right to peace. If your pet becomes a persistent nuisance, the body corporate can withdraw consent, provided they follow a fair, documented process. Whether you're currently in a pet battle or you need advice on another sectional title topic from levy disputes to maintenance rules, leave a comment below. We're answering your questions directly to help you navigate these tricky regulations. Let's make scheme living work together. The walls have ears, but only the fly on the wall has the answers. Don't let your scheme stay in the dark. Hit subscribe and stay savvy. I'm Savvy Scout, and I'll be watching. Buzzing off for now.